Hello, we are going to be discussing chapters 1 and 2, or chapters 1, I'm so sorry, today, legal framework affecting public schools. My name is Mariah Neal.
I'm Trent Stryker.
Justin Fickle.
Mason Verbka.
Dan Krychek.
All right. Like I said, we're going to be just talking about chapter 1 today. So within chapter 1, it talks a lot about the Bill of Rights. The Bill of Rights represents the primary source of just individuals' rights and freedoms within the Constitution. There are the first 10 amendments to the Constitution, and they are viewed as the basic rights and liberties of free people because they place restrictions on government to not intrude on individuals' lives. So what those restrictions really mean is that they cannot impose certain powers to free people, and they cannot, so just for example, one amendment is the government cannot pass laws prohibiting free speech. The federal Constitution. So the Constitution of the United States is the basic law of the land. It is the highest form of law that all citizens follow, and it provides a framework of law in which government follows. There are certain statutes. All statutes that are the federal, state, and local levels are subordinate to the Constitution, making the Constitution the highest power.
All right, thanks, Brian. I think this is me now, right?
Yes.
So in those, in those statutes, they where it comes where they protect our, our personal and our property and political freedoms. The Constitution doesn't specifically mention education. It does, however, it does have a big impact on how, we run schools and the management of schools, mainly by the amendments, so that how we are protected by our amendments, even in the school atmosphere. So that kind of leads us to the state constitution. So with the 10th Amendment, it really says that anything not covered in the Constitution, states have that power to govern that, by passing different statutes and in their legislative process. So the state constitution becomes the basic source for our rights within a state that you live. And again, the big thing is that they can't overreach the federal government, the Constitution. They can't be unconstitutional laws, but they can address those areas where maybe the Constitution doesn't cover. In the state constitutions is where we find the funding and the directions and recommendations for how public schools get ran, like we said, because that the education has been delegated to the states to be in control of, as long as they are constitutional. Kind of mentioned this a little bit in the previous slides, but so the state constitutions, they may exceed those areas where the federal constitution doesn't meet, doesn't cover everything. But like you mentioned earlier, it can't contradict that. It cannot be unconstitutional in whatever they pass. And how the state legislatures do that, the main way is by passing statutes through their legislative branch, which is why, we know that the state legislature is in charge of public education. And one of the main ways they do that is through statutes that they pass. And through these statutes, most school boards recommend making their policies based off of those statutes that become passed. It's kind of the most effective way for the legislature to make new law, to change old laws, which really, as educators, it stresses the importance of why we need to pay attention to, especially as admin, why we need to pay attention to bills that are on the board and proposed and that are being passed, because those will have direct effect in our school systems. So being, up to date on those is vital. All right, I think is someone else taking over from here?
So quarter case law. Case law is just reflected in a judge made or common law. With case law, it's sometimes viewed as an unsettled law because occasionally courts render conflicting rulings within their jurisdictions. Common law consists of judgments, opinions, and decisions of the court, adopting and enforcing preceding precedents or past court decisions. So not absolutely bound by common law entering a decision. State and board educations. These are just administrative agencies created by state legislator. They determine to some degree the direction of education in the state, and then public schools are under the control of this Board of Education. There's also 6 powers that most Board of Educations have in common. Certification standards for teachers, graduation requirements, the state testing programs that are used, accreditation, and approved budgets. Local school boards. So local school boards impact education policy and administration and supervision of school boards within their district. The broader role involves the formulation of the school district policy, which must be consistent with the state statute, like Trent kind of mentioned earlier. Policies are just by rules and regulations that provide for operations of schools. Board members are either appointed or elected, usually an odd number of people to break ties in voting matters. Local school boards are accountable to the public, and usually the vision of the school district is aligned with the mission, and kind of their most important role is the hiring of the superintendent.
So the U.S. system of courts, the judicial system consists of the federal and state courts, and they can only hear cases, obviously, that are brought to them. The organization of the courts at both levels is essentially the same. So we have trial courts, intermediate courts of appeal, and then the highest court, obviously, is the Supreme Court. They settle controversies, interpret legislative enactment, and obviously if it's something is constitutional or not. So the federal courts typically deal with cases involving federal and constitutional issues. So if something is constitutional or not, is it involving someone else or not? Along with that is cases in which the parties are residents or of different states. So if someone's a resident of Nebraska and someone's a resident of South Dakota, obviously you can't have the states hear about it. So we need to go up into the federal level and get a little higher. The federal court system includes district courts and appellate courts, and then the Supreme Court. So you go from one court to the other based on how the appeal process works and who has jurisdiction, which will be talked about later. There are 95 federal courts in the United States. At least one federal court is found in each state. Some states have more, such as New York, California. That's just because they have more people, so they're going to need to hear more cases. And that's kind of just one of those things where if people have more people, they're going to need more things to do. Federal courts usually hear cases between citizens of different states and cases involved in legislation of federal statutes. The appellate courts are represented by the courts of appeal, and there's 13 courts of appeal, and they're separated into different districts. different states are clumped together and use the same court, the appellate courts. In the District of Columbia gets one, and then others that involve 3 specialized federal court systems.
All right, the appellate courts, they're going to look at what the lower courts did in terms of procedure and law. They also decide if there are any misinterpretations of constitutional law. This is where some cases can get decided by technicalities. If the lower court missed something, they never retry the case. They're just looking to see the process at which it was decided was fair. State courts, this is where most of the educational law cases are heard because the Constitution left the education up to the states. Therefore, they usually are not a federal issue. The same way that the federal courts, as the federal courts, or lower courts, appeals courts, and Supreme Courts inside the states as well. Courts of general jurisdiction are your district or circuit courts. These would cover most cases that are appealed out of the lower courts. From here, cases would get appealed to higher courts like this, either a state Supreme Court or could go to a federal level if they decide that. Courts of special jurisdiction, also known as limited jurisdiction courts. These are your small claims courts, your traffic courts. This is where if you're going to go fight a parking ticket or a speeding ticket, you go to one of these type of courts. Your intermediate appellate courts. These are your courts that look to see if there's substantive or procedural errors in applying the law. Again, they don't retry the case. They're just looking to see if the case was tried correctly. They're just kind of looking for errors, make sure the trial was fair and followed the rules. The Supreme Court, this is your court of last resort. They have the last say and can only be overruled by amending the Constitution. So whatever they decide kind of goes. The decisions that are made at the Supreme Court are then used to kind of by the lower courts to interpret the Constitution, make decisions. Most of your landmark cases that everybody knows about are here. Currently, it's made up of 9 justices. They're supposed to serve for life. Some of them retire early, but it was intended that way to try to keep the court apolitical. That's something that's kind of been a controversy and in the news a lot lately. And the only way they can hear the course, or the only way they hear cases are on appeal, or if they decide that they want to hear it, which is a writ of certiorari.
All right, thank you. That was information from chapter 1.